Minor versus Gilmore, which began as a conflict in the 1850s between two prominent citizens of the village of Granby in Canada East, which is today the southern part of Quebec. Harlow Miners Tannery on the south bank of the Yamaska River, the town's major industrial enterprise, was powered by water directed from a dam in the river. You can see the dam here. But Francis Gilmore, the town's storekeeper, had been opening a sluice on the north side of the dam in order to allow the water to flow through and power his grist mill downstream. You can see the sluice gates there as well, on the left side of the picture. Miners sued Gilmore to put a stop to his interference with his business, and the case was appealed all the way up to the Judicial Committee of the Privy Council in London. And I'd like to use this case to examine the way in which the British Empire served as a forum for transfer of not only of common law norms, but of other legal norms, in this case, French civil law. And as the judges of the Privy Council recognized, the law governing the conflict in formerly French Canada was the law of the old French Empire, ironically no longer in force in France itself, since the Napoleonic Code was adopted, but preserved in the British colonies that had been conquered from the French before 1804. Indeed, the lawyers arguing the case before the British court in Westminster cited Justinian's Digest, Cotier, the Custom of Paris, as well as common law sources. And the Privy Council arrived at what I would call a weak conclusion. It did not appear that for purposes of this case, any material distinction exists between the French and the English law. According to both legal systems, the court opined, Minor could not demand that Gilmore keep the dam gate closed all the time. The decision's exposition of this and other principles of what Lord Kingsdown, writing for the court, termed the general law applicable to running streams. I mean, the general law, French, English, doesn't really matter. According to him, it's common to all legal systems, or at least in English and French. This decision went on to be cited extensively throughout the British Empire and beyond, i.e. the United States, as the definitive statements of the rules of riparian rights in the common law world. One might frame this episode as one in which the expanding British Empire encountered legal norms of the old French Empire through conquest, assimilated them into the common law, and then spread them throughout its possessions around the world. Alternatively, one might frame it as one in which British lawyers, despite the professed recognition of the legal distinctiveness of this civil law province, essentially ignored French law and imposed, in an expression of imperial power, their own law on the conquered land. Yet deeper reading of the law of Canada East reveals that the cross-legal histories of the British and French empires was more complex than either of these two stories might suggest. One hint that something more than simple merging of two imperial legal traditions was at work involves the sources cited before the court. In addition to the civil law sources I discussed previously, and the parties also relied on two sources which were neither French nor English, James Kent's Commentaries on American Law and the leading American water case of Tyler versus Wilkinson. To understand why American sources were cited in a British court adjudicating an issue meant to be determined by 17th century French law, we need to go back across the Atlantic to Canada East. From as early as 1832, water law cases in what is now Quebec cited Kent's commentaries as authority. One egregious example was the dissenting opinion filed by Judge Thomas Aylwin in 1860 in the appeal of Brown versus Bougie to the Queen's Bench of Lower Canada. It included a verbatim quote of 10 pages from Kent's discussion of riparian rights, footnotes and all. Now, I'm not going to be able to talk about this today, but Aylwin was clearly doing this for the benefit of the Privy Council, a topic which maybe I'll talk about in Barbados this summer. Why did lawyers and judges from the French law province of Canada East look south of the border for legal principles and rules in water law cases to a jurisdiction that had never belonged to the old empire from which the local law derived, so there's nothing in common with French law, and no longer belonged even to the new empire, of which Canada was now a part? In his dissent in the 1859 case of Boswell versus Denis, Judge Aylwin indicated one reason why Canadians may have preferred American law over French law in some cases. He wrote, "Our rivers cannot be compared with those of France or Europe." Following a tradition going back to Montesquieu and further, Aylwin argued that French law could not apply unmodified in North America as it was developed for a different set of environmental circumstances, and he therefore preferred the American test for a public river over the French test. Yet it seems that this was not the only reason for Canadians to turn to American water law. In the portions of Kent's commentaries quoted in Elwin's opinion, the American jurist appropriately cited a large number of American and English cases, but his very first citations were to civilian sources. And you can see this up here, Digest, Potier, Touillet, and then down here as well, he cites Berlin's encyclopedia, essentially, on French law, and the title on Cours d'eau. So Kent himself cited an awful lot of civil law. Later commentators, recent commentators, have divided as to what extent Kent's use of civilian sources was substantial or rather mere window dressing, with Alan Watson arguing that Kent's use of the Roman and French sources in this section in particular was riddled with errors and that it provided little support to his exposition of riparian rights. Nonetheless, it seems that Judge Elwin, in the 1850s and 60s at least, did see Kent as a good civilian source, prefacing his long quote from the commentaries thus: "I think it proper to avail myself of the valuable observations of Chancellor Kent. They are so apposite and so conformable to the principles of civil law that I cite them with as much confidence as if I were citing from civilians or French writers." So, Alan Watson notwithstanding, we have here a Canadian judge who did think that Kent knew his civil law. Justice Jonathan Sewell cited Kent not only in support of his decision of American law, but also in support of a point of French law. So as you can see here in this citation from a French case by Sewell, sorry, from a Canada East case. So he says here in the decision, he says, accordingly in the law of France, navigable rivers, blah, 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 footnote C, and then footnote C, he quotes several French sources, and then Kent is here in this string cite of French sources. Right, he's citing Kent along with French sources to prove a point of Old French law. So it seems that Canadian lawyers and judges were attracted to American water law, not just because of similar geographic conditions, but because they saw the law expounded in the American sources, particularly Kent's commentaries, but not only. And I have an article on this, which I have a lot of other sources there as well. They saw these sources not as American law per se, but as reflecting French law of waters applicable in Canada as well. So going back now to London and the Privy Council, in Minor versus Gilmore, what brought the English lawyers and judges to turn to Kent's discussion of water law? So it is possible that Kent's discussion of the topic was simply the best that was available at the time. Maybe in English, it was one of the better sources around at the time. But it is also possible that their exposure to the opinions of Canadian judges and their reliance on Kent in Minor and other Canadian water cases was decisive. So Minor is not the first Canadian water case that comes to the Privy Council. There's a series of them, and in all of them, you have the lower courts relying heavily on Kent. So the British judges in the Privy Council, it's the same judges sitting in many of these cases, are aware of this reliance on Kent, or at least prime them to accept Kent as an authority. In any case, the conflation of civil and common law of waters continued in Minor versus Gilmore, and it continued into Minor versus Gilmore's reception around the British Empire, which I'll talk about very briefly now. So Minor's summary of the relative rights of riparian owners, which was regarded as definitive for the rest of the 19th century and beyond, was cited widely throughout the empire. And though it arose again in a case on the periphery in which the applicable law was Old French law, it was taken as a faithful exposition of the common law of England, the imperial metropolis. I'd like to focus for a moment on an 1885 case from Cape Colony called Commissioners of French Hook versus Hugo, an appeal to the Privy Council from the Supreme Court of Cape Colony in Southern Africa. And the law that governed this dispute was supposed to be Roman Dutch law. And like the pre-revolutionary French law enforced in Quebec, Roman Dutch law was based on civilian jurists. And so in this case as well, lawyers for the appellants cited French treatises in support of their argument, in addition to Roman Dutch sources. Writing for the Privy Council in this decision, Lord Blackburn referred approvingly to the summary of the law of riparian rights in Minor versus Gilmore as reflecting, quote, the old French law. So Minor versus Gilmore, on the one hand, he says it reflects the French law, therefore it's applicable. However, finding that an important difference was said to exist between Roman Dutch law and English common law, which I won't get into now, he made an odd argument. explaining that his court had a very grave doubt whether that which was alleged to be in Roman Dutch law could be so. The English laws laid down by Lord Kingdom being so much more convenient. This is a very odd legal argument. But his characterization of the rules of riparian rights, as explained in Minor versus Gilmore, on the one hand as being the old French law, on the other hand as being the English laws laid down by Lord Kingdom, raises the question of whether the Canadian case's wide influence on the law of the British Empire should probably be viewed as reflecting the impact of French law, French imperial law, on British imperial law, or simply as the result of particularly persuasive British authority. So it's a sort of methodological problem I think we have here. So to sum up, it seems that the empire was fertile ground for the transfer of legal norms from the civil law to the common law world, catalyzed with the aid of American legal sources. The review by the Privy Council of the Canadian dispute was the occasion for the authoritative judicial pronouncement on the unity of French and English law, and for export of this homogenized conception of the law to lands as far afield as India, Australia, and South Africa. Yet we cannot say for certain that it was the particularly imperial combination of French and English law in Canada that led to this transplantation of American and French law into the common law. There may have been at work here an idea that, as Lord Kingsdown put it, there was a general law that was neither common nor civil. So it's possible that Kent and other American sources were seen as authorities of French law, but it is also possible that they were simply taken to be good sources of the general law of waters, as Kingsdown said, which is applicable in Quebec or in Cape Colony or in England as well.